Good afternoon. This is Sean Golding with Golding & Golding, here to discuss the basics of dealing with the IRS Office of Appeals. Is it worth it? Is it the right move for you? Some of the pitfalls and things of that nature. So, IRS Office of Appeals, quote-unquote, independent authority. Generally, what will happen is you receive a notice of a tax debt, or maybe you went through an audit. It doesn't turn out your way. You get proposed changes. Maybe you received a CP15 assessable penalty, and you have the opportunity to go to the Office of Appeals, right? Generally, if it's not an assessable penalty, which is like a 3520 or 5471, which are issued or assessed before you have an opportunity to dispute. Other types of penalties, taxes, you're dealing with the underlying agent, examiner, you're going back and forth, it's just not working out. And sooner or later, you get the opportunity to go to the Office of Appeals. The question is whether it's the right move for you. So the appeals process can be good. There are some benefits to it. It comes relatively quickly. Normally what will happen is you'll get a 60-day notice to appeal. It's supposed to be an independent authority, and all kidding aside, it typically can be. I mean, we've been successful at the appeals level where the IRS agent just wouldn't budge. So it's not like it's just a continuation of dealing with the agent. Appeals officers have some authority, not as much as settlement officers, but they are independent and it can work in your favor. Typically, once you send in that you want to do the appeal and you go through the process of submitting the proper documentation and paperwork, the hearing date comes relatively quick. I say hearing date, it's not necessarily like you have to go anywhere. You're supposed to get a hearing. It doesn't always happen that way, but oftentimes you, the taxpayer, or your representative, more often than not, you'll just have your representative appear by telephone. You'll discuss the case. It comes faster than a collection due process hearing, which we'll get to in a minute. And there is some finality to it. If you win, for the most part, that's the end of it. If you lose, you may be able to go to tax court in very specific situations. Maybe the IRS overstepped the boundaries of their power and things of that nature, but it's not as direct as if you do a collection due process. Which takes me to the next part, which what are some of the appeals process pitfalls. If you do the appeal, then you generally don't get the opportunity to do the collection due process. That is not written in stone, but there have been some cases that basically say, hey, if you want to do a collection due process and you've already done an appeal, well, you've already had your bite at the apple. There are some ways to circumvent it, possibly if there's some additional facts, things that couldn't have been discovered, things of that nature, but you may lose the right. The reason I talk about the collection due process so much is that unlike the appeal, the collection due process, you can go to tax court afterwards, and you're dealing with a settlement officer, not an appeals officer, which is a little further removed from an agent or examiner, which is a good thing. And if you lose, you can go to tax court. They have to take into consideration at the collection due process. I mean, they have to take into consideration cost of litigation. Essentially, with the appeals, it's pretty much the end of it. And that doesn't mean it's not going to come in your favor, but if it doesn't, then they can kind of close the books on it. With a collection due process, taxpayer can go to tax court, and then oftentimes what will happen in tax court is the judge will say, just kick it back to appeals or to collection due process, to a settlement officer again. So you get a lot of rounds, and they have to consider this whether the IRS has a strong position or not. A lot of times with the appeals process, it can feel a bit like an uphill battle because you're just dealing with one person, and because it's called the IRS Office of Appeals, you get the sense that you're really just dealing with the IRS. If you're out of compliance and you haven't been penalized yet, you haven't walked down this road where you've been audited or examined or received an assessable penalty, you may want to consider one of the offshore disclosure programs, otherwise referred to as FBAR FATCA amnesty. If you're willful, you just can't certify under penalty of perjury that you're non-willful, you would do the voluntary disclosure program. If you're non-willful, there's a lot more opportunities available to you. There are the streamlined procedures, delinquency procedures, and reasonable cause. We have a whole bunch of information about this stuff on our website and our sub-websites. You can always reach out, schedule a reduced fee initial consultation if you think it's appropriate, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.